Hi, I'm here today with the state's team that tried the opioid trial against the pharmaceutical company Johnson & Johnson and its subsidiaries. They won a big victory, a $572 million victory for the state. And we're here to talk a little bit about the verdict itself, and now they've had a day to read it and think about it a little bit. We were asking them all kinds of questions yesterday, but they did not have that opportunity before. So let's start there. General, and now that you've had a day to read the verdict and think about it, what new thoughts do you have about it?
Well, I think the important thing writ large here is the judge's findings, his specific findings of their misconduct, of their activities, and the extent to which they were the direct cause of the opioid epidemic in the state. So we've had a little bit of time to look at the order, and I think Judge Burges is maybe going to talk about that a little bit, but we feel good about where we came out. 20 plus months of discovery, depositions, millions of pages of documents. The state's team did a great job, and that was literally cause and effect of why we were successful at the trial. But again, the judge's order is really a template for this defendant's activity and why they're responsible for what happened here in the state and why they need to write a check.
Okay. Judge Burge, tell us a little bit about your observations.
Well, when you look at this order, it reveals and pulls the onion back about the conduct of Johnson & Johnson and what they did in the state of Oklahoma. Probably did it elsewhere, but we have direct proof in Oklahoma. For instance, they did engage in false and misleading marketing, and the law is clear that such conduct qualifies as the kind of omission and creates liability under the nuisance law. It goes on and on about their marketing activity and what they did, and it also addresses the unbranded marketing of opioids, and we now know why they were doing unbranded marketing is because they were supplying 60 to 65% of the API to other manufacturers such as Purdue or Teva. So the 1% argument, he tears right through that and shows that they were a major player, 60% or more of the opioids that were sold and distributed in the state of Oklahoma. He describes their conduct in detail about how they went into the doctor's offices, how they had misleading material, how they misled with studies and so forth. He really tells a story here about Johnson & Johnson. So that's what he did, and I'm proud of Judge Bachman for taking this stand, and it'll be a national stand.
You all had asked for a little over $17 billion. They came back with $572 million. The big difference being his judgment says to fund it for 1 year. You all were saying that it would take 30 years probably to really abate the crisis in Oklahoma. What do you think you can do with 1 year's funding? I mean, where does that leave the state? What can the state expect?
You want to answer that, Terry?
Absolutely.
Yeah.
I think that the judge's order was incredibly validating of the abatement plan and all the hard work that went into it. Well, certainly I understand that I testified as the primary architect. There were lots of state agencies, lots of folks, lots of people who put their time in. It is a comprehensive abatement plan that is evidence-based, the bulk going to treatment, but it also includes prevention, it includes community education, medical education, all of those things we know that can abate the crisis. And when you read the order, well, the only non-lawyer in the group, the fact that he talks about each of those items in the order and cites them and says this is a year one plan, this is going to be a great step. This year one gets our foot taking a giant leap forward that's really going to allow us to be potentially the first state in the nation that actually abates this crisis.
The pharmaceutical companies said they're going to appeal, so you all are more familiar with the process than I am. How long was that process likely to take? How long would it be before the state sees any money, presuming that it's upheld, which may or may not happen?
Well, our team is and has been ready to deal with the appeal. I'm going to let Brad Breckworth talk a little bit about how we're ready and how we're not stampeded by their threats to appeal.
Okay.
Thanks, General. You know, we started working on the appellate process in this case before we ever filed it. And so working with General Hunter and his office, relying on his folks who've been here in Oklahoma forever, and Judge Burges, who's probably one of the more respected lawyers in the state, we have a plan. And everything that we did from June 30th, 2017 through yesterday was calculated to deal with Oklahoma law straight on. And I think Judge Bachman, being an Oklahoma lawyer and a legislator, is right on the money in most aspects of this decision. He was very fair to both sides, and he let everybody put on their case. So I think we're solid on appeal. We've got one heck of a legal team. You know, we would hope that Johnson & Johnson would do the right thing and step up and actually help us in this state. They refused every opportunity to do that. And you know, you heard us talk about in trial, I mentioned it a lot. This gentleman started a commission before the lawsuit. And we had public and private sector folks involved. We had Republicans and Democrats and independents involved. We had Commissioner White involved. Everybody who was a stakeholder in this problem showed up to explore non-litigation ways to fix this problem, except Johnson & Johnson. They were still lobbying, they were still trying to go to our boards to get their way, but they wouldn't step up and meet with the folks bringing this case and trying to solve the problem. They had to be held to litigation. So if appeal's the way they gotta go, so be it, we're gonna win that. And I'd also just say real quick about this commission, you know, it's my opportunity maybe to speak to you too. I don't know that the citizens of Oklahoma fully grasp what went into this case and how hard these two folks fought for them. Johnson & Johnson is one of the most politically and business influential companies in the entire world. When you're worth $370 billion, you can get away with just about anything. General Hunter took a stand against them that no other attorney general had taken. Nobody wanted to go after Johnson & Johnson. They're too big. Everybody went after other companies, but not Johnson & Johnson. And he's withstood a lot of scrutiny and a lot of attacks by this industry. They're still doing it today after we've won. So I think every person in the state of Oklahoma owes his office a debt of gratitude. You know, they're the biggest law firm in the state. They have a lot of other responsibilities, but they've worked tirelessly as state leaders for the smallest individual, no matter who they vote for or what they believe in, because he knew it was the right thing to do. The same thing as Commissioner White. You know, she's been out here fighting this thing for over a decade with not enough people and not enough resources. The state just doesn't have the ability to fight drug companies like with the kind of money they have. And I think we made it clear that she is the best person you could have working on this type of problem. And I hope that people will look at the abatement plan, and there's a lot of it here in the order that Judge Burge has, because I think our leaders here can look at it and draw upon things they might want to do in the future, not for me to say. But I think other states too should look at what she and my partner Lisa Baldwin and Reggie Whitten, who's not here with us today, put together with General Hunter's team, because it is a roadmap of how to fix this. And it's time to quit talking about it and get to doing it.
But how long does the appeal process take? I mean, you've handled appeals in your lives. What should people expect before the state might see any money from this?
Well, let's let he actually wore a robe at one time.
He did.
Yeah. What do you think, Your Honor?
Well, in an appeal, the thing that holds up, what takes up a lot of time is getting the record prepared. But we had daily copies, so the record's prepared. So we can, you know, if they file this appeal, we can respond promptly. I would hope that the Supreme Court of Oklahoma would retain jurisdiction on this so that we could get a decision sooner or later, and maybe that could happen within a year. Now, if they go to the United States Supreme Court and request cert there, that could, you know, take another year or so. Maybe 3 years, but 2 to 3 years, I think, is the appellate track on this thing. And they can address the merits in the Oklahoma Supreme Court. They can attack rulings and so forth. But in the United States Supreme Court, when they apply for cert, the basis for the Supreme Court accepting cert is very limited. And they're going to have a constitutional issue, the United States constitutional issue, for the United States Supreme Court to accept cert and want to look at this case. And like Brad said, from day one, we've had counsel in this case looking at these constitutional issues, and they've been here from day one, and we think we're in good shape. It's just like Judge Baltman found. The Constitution doesn't allow you to go out and lie and deceive doctors. That's not protected by our Constitution. So we'll see. I'm confident that, that we have a good record and that we're going to be successful on appeal. I'm also confident that I don't think the United States Supreme Court's going to want to look at this on behalf of the drug manufacturers and what they've done, but we will see.
Can I add one thing
Sure.
to that about retaining jurisdiction? Because I don't know that everyone knows how we got to trial. General Hunter ordered us, when he hired us to take this case, to pretty much drop everything else we had, work, family, which we did. The folks at this table and many others have dedicated 2 years of their life to this, just like he has. Judge Baltman did the same thing. There are other cases that have been out there 5 years and they don't have a trial date. We completed this from filing to finality in 2 years and 2 months. And the reason that he ordered us to do that, and I think the reason Judge Baltman did it, was that we lose 1 to 3 people a day here in Oklahoma. And so every day that we wait, we delay. That's another child, a parent, husband, wife that dies. And we also have this problem with babies that are being born addicted, essentially. So I hope that our court will retain jurisdiction, because that could save us a year to a year and a half of assuming we were to prevail. If we wait another year and a half or 2 years beyond that to start letting her office and whoever else in the leadership of the state will be involved with the judge, we could lose, think about that. I mean, we could lose another 100 Oklahomans. And we can't wait. So I hope that your readers and anybody looking at this fully grasp the exigency of this problem.
I don't know if everybody understands the way the process works. The Supreme Court could send it to the Court of Civil Appeals if it chose. And
Yeah, what can happen is once it's appealed, they can assign it to one of the courts of appeals for a decision. And then if they do that, then if either party's not satisfied with that decision, then they can go back to the Oklahoma Supreme Court. So it adds several months to the process. And we can ask, if an appeal is filed, we can ask for the Oklahoma Supreme Court to retain jurisdiction of the case, and then it's their decision as to whether they will or not.
now, it's my understanding the state, if it chose to, could appeal the amount of the verdict. Is that correct? Is there any thought given to doing that?
Well, this is a chess game, and it's not Chinese checkers, it's chess. So we're thinking several moves ahead. Judge has done a good job, and our team's done a good job so far of getting the big picture established with regard to what the order means, what it represents. But where we go from here is as George Bush used to say, strategery. And so we're not going to say to you today, Randy, that we're going to do X, Y, or Z with regard to the judge's decision. We think the judge's decision is sound. We think his findings of fact accurately represent the evidence in the case. Our position is that the sooner that the CEO of Johnson & Johnson can avoid the hypocrisy of saying that they're changing their approach to responsibility, that they're going to move towards stakeholder and systemic responsibility from just taking care of their shareholders, the better. Actions speak louder than words. He needs to write a check.
Early on in the case, you had them charged with fraud and unjust enrichment, and they dropped it for this case to speed it along. Is there a possibility of refiling those types of charges? Is that an option that's available?
Again, you're asking us to share strategy with you, Randy, and we certainly respect the Fourth Estate, but in this situation, we're being very thoughtful and very deliberate about next steps.
Let me ask you this. The trial itself had a lot of publicity, not just here, but across the nation. Do you feel that the trial itself has had an impact on people's knowledge of opioids and what they do, and may have its own abatement impact separate from the amount, that it may cause people to be more cautious in how they use opioids?
There is no doubt that when General Hunter stepped up to, and we've talked about this being a David and Goliath situation, as you've heard talked about today, many of us have been on the front lines for years trying to fight this, but it wasn't until General Hunter stepped up and made this a statewide national discussion that we got more attention. Now, do I believe we need what's in that abatement plan and what's been ordered? Absolutely, because Johnson & Johnson and Janssen did an incredible job of lying to people for over 2 decades. And people were under the impression, and still are, that this is medicine, so it must be safe. And in fact, this is deadly. But we have made progress, and we will continue to make progress until every Oklahoman is safe. We've lost over 6,000 Oklahomans, and we're not willing to lose one more.
One of the charts you had showed that the rate of Oklahomans that are dying from overdoses has actually started to decline within the last few years, even before you had the verdict rendered. So I take it that's something you're proud of.
Oklahoma is actually leading the way in the implementation of evidence-based treatment, prevention, and education, and we've had one of the largest drops in both opioid prescribing as well as opioid overdose deaths. We've equipped more law enforcement than almost any other state with naloxone, which is a life-saving medication that will help someone breathe until they can get to the emergency room when they're in an opioid overdose. So we are absolutely making progress, which is why I was humbled to see the judge's order talking about the importance of these steps and really validating these are evidence-based gold standard practices that he wants to ensure we do more of in the state of Oklahoma.
So what's next?
I'm gonna go see my family. I think Lisa might like to see her children for a while.
Yes.
And we're gonna get to work on what we anticipate to be an appeal, because this company just it hasn't shown itself to be able to accept responsibility. So until General Hunter tells us otherwise, we're going to stay on the attack and keep fighting for Oklahomans.
A lot of the other states have also filed against distributors of pharmaceuticals, pharmacy companies, taking kind of a different tack. Is there any thought given that maybe go beyond just the manufacturers with the state?
Stay tuned.
Stay tuned.
Will do.